Hello, friends, and welcome back to our series on Landlord 101 with Porcupine Real Estate and Ledgeview Commercial. Brittany Ping, welcome back. It's great to see you.
Thanks so much for having me. I love this series.
We'll do a number of these short videos that will help landlords, tenants, real estate investors, and even property managers do a better job and better serve their customers here in the great state of New Hampshire. So the topic we want to talk about today has to do with contracts. I mean, the first thing we learn in real estate school is all real estate contracts have to be in writing. Is that true, or can you just like sign a lease with a handshake?
No, so New Hampshire is definitely, we call it a handshake state in regards to getting a job. But in regards to engaging a real estate agent, whether that's for buy sell or for property management, or whether that's in getting a tenant, someone to lease, or whether you want to lease, a lease is a written contract. Any of your real estate business should be in writing for it to be valid and enforceable.
Okay, good. Now, from a landlord or property manager's standpoint, also, if you're going to have a notice of a rent increase or eviction or something like that, it's my understanding those definitely have to be in writing, or oftentimes the courts will side with the tenants. Is that true?
Absolutely. So even if you go to court without the lease that you have in hand, that written lease, the judges will make a determination based on what's verbally presented. So having that written document and bringing that written document to court or to an issue that you have, whether it's like an arbitration or a mediation, something like that, it is absolutely imperative that you have those written documents and that you bring them with them, because the judge might also just consider your testimony to be a written contract. They won't, if they don't see that paper, you could be found at fault for not having that written contract on file.
Yeah, it's definitely good advice. The same goes with paperwork like disclosures. Often those are part of the contract, or at least an amendment to the contract. We can talk about the lead paint disclosures or seller's property disclosure. I mean, those things are very important documents that you want to be sure both parties have signed and have a copy of.
Yeah, so even something as simple as a recent buy-sell that was done here, right? Owner was going to occupy. Nothing was written in the contract about what they wanted to do with parking. So, the owner was moving in like, I don't have a parking space. Absolutely correct. You don't. You need to change the policy. That's 30 days. It was not in your P&S. That's what you wanted. Luckily, we were able to help that owner out and get them what they were looking for. But it's one of those things, it happens a lot with, as a landlord, where someone will say, well, I told you that I get paid every other week and I'm going to pay you every other week. You're not going to get the full rent. Okay, you telling me that versus your lease saying your rent is due by the 1st with a grace period is totally different. That's not what your lease says. It does not say you pay bi-weekly rent. So if it's something like that's important to you as a tenant or as a landlord, just making sure your terms and conditions spell out what's actually happening. Because if you say, hey, but we had this verbal conversation, that's not what's in writing. That's not what the terms of your lease are. And one of the pieces, like you mentioned, policies and procedures can be changed with 30 days notice. So if parking, laundry, storage, maintenance, anything like that can be changed with the landlord with 30 days of written notice. Something like the terms and conditions of your lease, those can't be changed with the 30 days written notice if you are in a lease. So if it says that your rent is going to be $1,500 a month through the end of the next calendar year, it cannot be changed until the end of your lease, right? So you might say, oh, if it ended on December 31st, that owner would need to notify you of any changes to the amount of your rent or to your lease terms. Like if they wanted to extend a renewal or put you in holdover, that would have to be done before December 1st of the end of that year for it to be valid. They couldn't change it for you on December 1st. You have to honor that lease term.
Okay, here's another pro tip for our fellow landlords, realtors, and some of our clients, is that nowadays a lot of people are using texting for these messages.
Ooh.
Or Signal, which has disappearing messages. So pro tip, take a screenshot or cut and paste all those messages from your chats and texts and put them into a document and save that document, because it could really save your bacon later on.
And the thing is that they're still not clear in New Hampshire. So New Hampshire is still a gray area, whether texts are confirmation of a written notice. Okay, so you also don't want to be that text case. So if it's worthwhile for you to get that confirmation in text, it's worthwhile to follow up with an email. I am following up on our text that where I notified you that your rent will be X, and maybe you can attach the screenshot of that text. But I would absolutely, from my perspective, that cover your butt mentality. Do not rely on text as written notification. That could come up and not be valid. It's not specifically a valid written contract per state law. Could be per case law, depending on what happens. We haven't seen it yet. We've not seen it argued yet, but I wouldn't chance it.
Okay. Well, that is great information. We'll remind our viewers that these videos will be available on our YouTube channel for Porcupine Real Estate. And it's tinyurl.com/NHlandlord101. I believe that's in the notes scrolling below. Brittany, thanks again. Look forward to seeing you soon.
Thanks so much.